Assalamualaikum warahmatullahi wabarakatuh. We have come to the final part of our topic, mistake. Okay, so inshallah we are going to cover everything about mistake today. But basically, the subtopic that the focus for today's lecture is unilateral mistake. Okay, especially for English law. Okay, the rule under English law, and then it concerns with contracting parties. Okay, why we are discussing English law? Because most of our contract law, okay, law relating to contract, sorry, actually it originates from English law, okay, common law. So as far as the position of unilateral mistake under English law is concerned, okay, with regards to contracting parties, okay, as you can see the title here, okay, our Contracts Act, okay, actually is silent on this. Okay, we don't have any specific provisions, okay, governing this. Even the decided cases, case law, okay, we don't have specific rule, okay, governing this. So that's why it's very important to know, okay, what's the position of English law on this matter, okay, all right. And then even the rule itself, okay, it has different approaches, okay, when it concerned with or it involve contracting parties here. So we are going to look at some of the decided cases, okay, in order to interpret, okay, the rule or the law, all right. So the rule actually, it is divided into two approaches here, all right. The first one, mistake, okay, made, all right, by one party. Okay, remember, it's about unilateral mistake. Okay, mistake made by one party as to the identity, okay, of the other contracting party. So what's the position of law in that situation? So the contract will be considered as void, no effects whatsoever, not enforceable. Okay, another mistake, okay, which could happen, okay, in relation to unilateral mistake here, all right? Mistake with regards to the attribute of the other party. Okay, we are going to discuss what's the meaning, okay, what's the interpretation of the word attribute here, okay? So in that situation, if the cases involving mistake with regards to attribute here, all right, the contract will remain as valid, okay, as opposed to the first one, okay? If it is with regards to identity, then the contract is void. But if the mistake is with regards to attribute of the other party, okay, the contract is valid. Take note, okay, we are discussing about mistake with regards to the parties, okay, the person who enter into the agreement, okay, nothing to do with the subject matter. Okay, when we discuss mistake by both parties, okay, remember we discussed about subject matter. Okay, now we focus on contracting parties, the person, okay, the offerer, the offeree. Okay, all right. Okay, let's move further. Okay. Okay. So now we go to the first one, okay, the first category, which is unilateral mistake with regards to identity, okay. So of course the contract is void, like I said just now. So how it might happen here, okay, all right, this is the example of situation, okay, here, all right, it occurs, it happens where A, okay, contracts with B. So A and B refers to the party, okay. Mr. A and Mr. B, all right, they contract, okay, they entered into the contract. But A here, okay, believe B to be, actually believing B to be C. So meaning that here, in A's mind, okay, actually he has in his contemplation, all right, somebody else, okay, he wanted to enter the contract with C, but then it turns out that actually he was contracting with B. Okay, right. Explanation is that, okay, a party has in his contemplation, all right, a definite, a specific, and identifiable. I mean, you can identify specifically, okay, a person with whom he intends to contract. Okay, and then another requirement or condition here, the identity of the other party must be material. Okay, at the time when he makes the contract. In that year, if he doesn't enter the contract with that particular person, then the contract as if no contract. Okay, he doesn't want to enter unless it is with that particular specific definite person. All right. So we have a very classic case on this. Okay, the case is Candy and Lindsay. Okay, 1878. Okay, let's look at what happened in this case. Sorry, the facts of the case here. Sorry, happened. All right. Okay. So, okay, before we go to the facts, okay, this is basically the comparison, okay? Sorry, this is the further classification for unilateral mistake here, all right? All right. So for mistake with regards to identity, okay, actually it can further be divided into two subcategories. Okay, the first one, inter absentis. Okay, even the word itself gives you some hints. Okay, absent, and then versus inter presentis, present. Okay, here, all right. What's the meaning of inter absentis here? Why the parties, okay, are not physically in each other's presence. Okay, for example, okay, those days especially, okay, the parties are dealing by correspondence, by way of post. Okay, you don't see each other. Okay, all right. And one party, okay, is mistaken as to the identity, okay, not the attributes of the other. And the party intends, okay, instead to deal with some identifiable third party. And then the other party, okay, knows about this. Okay, of course, that's why it is considered as unilateral mistake. So in that particular situation, the contract will be void for mistake. Okay, that's the rule, void. Okay, but if still with regards to identity, but it is inter-presentis, okay, meaning that here you are face to face. Okay, the parties are face to face with each other. Okay, so there is a presumption. Okay, who makes the presumption? The law. Okay, legal presumption here. Okay, that the mistaken party intends to deal with the other person who is physically present and identifiable. I mean, you can see him in front of you. Okay, you can identify him by sight, by sound. Okay, so irrespective of the identity which one or other may assume, doesn't matter about your wrong or mistaken assumption, but the legal presumption is that, okay, the party intends to deal with the person who is in front of him. Okay, as opposed to inter absentis, you cannot see him in front of you. Okay, all right. If we were to apply to our current or present situation, I think maybe it is quite similar, equivalent to contract entered online. Okay, online contracts lah usually. Okay, alright. But again, it has some debates and rule governing that. Okay, we come back to the case of Kandi and Lizzie. Remember, we are discussing about unilateral mistake. Okay, alright. Regards to the identity. Okay, what happened Kandi and Lindsay here? A rogue, okay, the meaning of rogue here is dishonest or mischievous person. I think the more related term nowadays, okay, we tend to use the word scammer or cheater, all right? So the rogue here named Blanken, okay, so he ordered some goods, okay, in writing from Lizzie and Company, okay, all right? So Blanken here gave his address as Blanken and Company, okay, and the specific address here, okay, 37 Wood Street, Cheapside, okay, and he signed the letter in such a way that the name appeared to be Blankiren and Company. Okay, it's quite similar, right? Blanken and Blankiren. So the signature, okay, similar to Blankiren, even though actually the address is Blanken. Okay, and then, right, a very respectable firm known as Blankiren and Sons, okay, which carried on business at 123 Wood Street, was well known to Lindsay. Okay, when Lindsay received the order, the letter in writing here, right? So he thought he was dealing with this Blankiren because he only knew of Blankiren. Okay, all right. So and then Lindsay, because he has been dealing, he has some previous dealing. Okay, Lindsay did not ascertain their correct address. Okay, but he just dispatched, okay, delivered the goods to Blankiren and Company, 37 Wood Street, Cheapside. I mean, he quoted the number 37. Okay, I mean, he followed the address given by Blanken, all right, because he thought he was dealing with Blankiren, even though different address here. Okay, all right, so he didn't really verify or recheck the address, the number especially. So later, okay, Blanken, the rogue, okay, the cheater, was convicted of obtaining goods by false pretense because he pretended to be Blankiren, all right? But because it took some time for the trial to be completed, all right? So before his conviction, actually, he had sold some of the goods to Kandi. That's why you can see the word Kandi here, alright, Kandi in the ordinary course of business as the normal dealings, okay, alright. And Kandi resold them all to different persons before the fraud was discovered. So there had been dealings, okay, before the whole fraud, okay, was actually came to be noticed, okay, basically, and then the case was brought to the court. All right, so the court held that, well, actually, as far as the facts was concerned, so the court actually examined, okay, thoroughly, carefully, all the facts of the case here. So the court said, well, as Lindsay and company, okay, knew nothing of Blanket, all right, when Lindsay delivered the things, okay, so they don't know about the existence of Blanket here, all right, and they intended to deal only with Blankiran and Sons, okay, they thought they are dealing with Blankiran, not Blanken, all right. And then Blanken, the cheater, the rogue here, okay, know about it. Okay, he knows, okay, actually, Lindsay wanted to deal with Blankiran, not him, not Blanken. So the court came to the conclusion there was no common intention, okay, which could lead to any contract between the parties. You wanted to deal with somebody else. Okay, you don't want to deal with Blanken here. So eventually, okay, the legal effect is that the property in the goods, okay, remain in Lindsay, okay, it's still with them, okay, here, and Kandi had no title to them. The goods, okay, the property cannot pass hand to some other purchaser, okay, because why? The first contract was void, so there's no way that you can validate the void contract. Okay, so basically the Kandi cannot get the that's why Kandi is was suing Lindsay lah, alright, for the ownership of the property, okay, the stuff here, but actually it reverts back to Lindsay, the first owner, okay, because there's no common intention, no contract, no valid contract at all. So that's what happened in Kandi and Lindsay. Remember, it's about unilateral mistake with regards to identity, okay, and then it is contract made inter absentis because they were dealing through correspondence, okay. Okay, another subtopic, okay, for mistake with regards to identity, okay, but specifically another category for unilateral mistake here, okay, mistake with regards to attributes, okay, attributes here, right. So, what is it all about here, right? If the innocent party, okay, believe that he is dealing with a reputable firm, not a rogue, then the position is like what was decided in this case, okay? Actually, this is quite similar to Kandi Lindsay, but not exactly similar, okay? Similar, but then some differences. And then the court came to different conclusion. Okay, what happened in Kings Norton and Irish Marriott here, okay? Also very old case, okay, 1897. Again, it involved a rogue. Now, the rogue's name is Wallace. Okay, just now we have the name of Blanket. All right. So a rogue named Wallace. So he ordered from Kings Norton. Okay, this is the vendor. Okay, the seller. Some goods. Okay, on note paper headed Hallam and Company. So Wallace here. So he pretended to be Hallam and Company. All right. So and then for the first dealing here, all right, the goods were paid for by a check drawn by Hallam and Company. So Hallam and Company is the one who issued the check for the payment, okay, of the goods here. So everything was okay, all right. And later, the vendor, okay, the seller, King Norton received another letter, okay, purported, okay, appeared to be, okay, right, to come from Hallam and Company again, all right. So now containing a request for quotation of prices for goods. So they are ordering some goods lah. Okay, they ask for quotation and then they make the order, all right. So in reply, Kings Norton quoted prices, okay, and Hallam then by letter ordered some goods. Okay, after giving him the quotation, then Hallam and Company proceeded. Remember, it's a road, okay. Proceeded to order, okay, some goods here again by letter, right? So obviously, this is all cases buyer of inter absentis, okay, all right. So which was sent off to them. So here, Kings Norton just delivered the item to Hallam and Company. And then what happened was that, okay, these goods, okay, were never paid off, no payment whatsoever, all right? And then what happened was that, okay, Wallace actually, the rogue name, okay, had fraudulently obtained these goods and sold them to Irish Marriott. That's why you have this name here, Irish Marriott, okay? Who bought them? Bona fide. So Irish Marriott is bona fide purchaser. I mean, he wasn't aware of the earlier transaction which was tainted with fraud here, all right? So now the owner, okay, of the goods, okay, Kings Norton, okay, brought an action to recover damages, okay, compensation for the conversion of the goods. So now meaning that here the conversion is tax action. Okay, you are asking for the return as well. Usually you are asking for compensation, okay, monetary compensation. So Kings Norton suing Irish Marriott because now the goods is with Irish Marriott. Okay. All right. So when the case went up to the Court of Appeal here, okay, this is the rule. Okay, this is the observation. The court stated that if a person, okay, induced by false pretenses, okay, contracted with a rope, okay, to sell goods to him, and the goods were delivered, okay. So actually, in that situation, the rope could, okay, until the contract was disaffirmed, okay, give a good title to a bona fide purchaser for value. I mean, if the contract was cancelled before the goods pass hand to some other purchaser, okay, for value, so it's okay. I mean, you still have the right to ask for the return of your goods, yeah. But the problem is that in this case, okay, the good has passed hand to Irish Marriott, and Irish Marriott was bona fide purchaser, okay. And then the court said, well, actually, King Norton here, okay, you intended to contract with Hallam and Company. Okay, all right. So the writer of the letters was Hallam and Company. Okay, and then this is the differences. Okay, in how the cases differ with Candy Lindsay. Okay, the court said, well, if it could have been shown that there was a separate entity, okay, called Hallam and Company, and another entity called Wallace, okay, then the case might have come within the decision in Candy and Lindsay. If you have in your mind to deal with some other specific person, then I mean the first contract will be void from the very beginning here, all right? So in the opinion of the judge, okay, A.L. Smith, okay, here, there was a contract by the plaintiff with the person who wrote the letters, okay, by which the property passed to him. So King Norton's intended to deal with Hallam and Company, all right? And then actually there was a mistake here, right? But the plaintiff, he had not made any mistake as to the identity, but only to credit worthiness of the other contracting party. I mean, you intended to deal with Hallam Company from the very beginning. You thought he has money to pay, but later the item wasn't paid off. All right. So the essential point was that Hallam Company was Wallace. Okay. So basically, that's the reason, okay, the ratio for the judgment, why the case was decided differently compared to Candy and Lindsay. Candy and Lindsay, the vendor, okay, intended to deal with Blankiran from the very beginning, not Blanket. Here, you intended to deal with Hallam and Company, okay, all right. You just mistaken about the credit worthiness, okay, no money to pay. If got money to pay, then no problem, okay, with the transaction. Okay, for contract made inter presentes here, okay, all right. So, like, I mean, this is what happened. This is actually with regards to if you can actually see each other, okay, inter presentes, okay, face to face with each other. So even where the contract is not void, okay, it may be voidable for fraudulent misrep. So even though you can't really invalidate the contract under mistake, but you can actually make it voidable if you can prove fraudulent misrepresentation. Okay, but all right. But remember, it's not void, it's voidable. Okay, if the goods which are the subject matter have passed to an innocent third party, okay, so the before the contract can be invalidated, avoided, okay, the third party may acquire a good title because why the contract was just voidable. It's possible to be valid, especially if it has passed hand to the third party purchaser. Okay, bona fide purchaser for value without notice. Okay, this is the case to illustrate to us contract made inter presentes, okay, face to face with each other. Okay, here, Phillips, the earlier two cases, contract made inter absentis through letters, okay, through correspondence. I mean, you are not really face to face with each other. Okay, for Phillips and Brooks, okay, also very old case, 1919, okay, that's reported in King's Bench. So we have few parties here. we have North, okay. So Mr. North here, he represented, okay, in passionate, okay, to be Sir Judge Buloh. So meaning that here he pretended to be Judge Buloh, Sir Judge Buloh, okay. And then who was the plaintiff? Plaintiff was a ring jeweler, and then defendant was the pawnbroker. Okay, so the suit is between plaintiff and defendant. Okay, alright, meaning that here the ring has passed hand to the pawnbroker, Brooks here. Okay, so Philip, the jeweler, okay, asked him for the return of the ring lah here. Alright, what happened? Okay, so North, okay, the cheater lah basically, okay, here visited the jeweler, the plaintiff, alright, and he chose some pearls and a ring. So he pretended to be a buyer, okay, alright, purchaser, customer. And then he just walked into the shop lah basically, alright, the jewelry shop here. And then he wanted to pay with a check, alright, no cash involved here. So while writing a check in payment, okay, so he represented to the plaintiff that he was Sir Judge Buloh. So he introduced that, well, I'm Sir Judge Buloh, and then he gave the address, okay, the correct address actually here, right? Address of Judge Buloh here, okay, alright, St. James Square, London. And then the jeweler, okay, those days, because you can't really verify it through, because nowadays we have Google whatsoever to verify, all right? So plaintiff actually had heard of Sir Judge, okay, as a man of means, okay, a rich person, okay? And on referring to the directory, so he did try to double check in the directory. I remember my days, okay, those days we have yellow pages to check, all right? And from the directory, okay, he found that the address was correct, okay, but he doesn't know how Sir Judge Buloh looked like, okay, alright. So he therefore thought North is really Sir Judge Buloh, okay. So he allowed North to take away the ring and just paid through check, which you can actually cash later lah, alright. So obviously, because North was the cheater, the rogue or scammer here, so the check was worthless, okay, and no value, alright. So North was convicted of obtaining the ring from the plaintiff by false pretense, okay. So he was convicted later, alright. But what happened was that before the conviction, okay, North had pawned the ring with the defendant, okay, pawnbroker. And then the pawnbroker was not aware of what North had done, okay, in order to get the ring, okay. So who took it bona fide? So here Brooks, okay, took it bona fide without notice, okay, in the course of business, so given value. So he just paid the money. So it's not free of charge whatsoever, okay, value, given value for it. So now the plaintiff, the jeweler, the owner of the ring, okay, brought an action for the return of the ring, okay. That's why he was suing the pawnbroker, Brooks. Okay? The court held that, well, this is the contract inter presentis. Okay, you are able to verify. Okay, you were face to face with your customer. Okay, all right. So the court held that, well, plaintiff intended to contract with North. Okay, Phillips here wanted to contract with North. Okay, although he will not have made the contract, but for the defendant's fraudulent misrepresentation. So the case is more of a fraudulent misrep and not really a mistake lah. Okay, alright. Therefore, the property in the ring passed to North, okay, who could give a good title to any third party. So this is what happened actually. Okay, the title in the ring, okay, had passed hands to Brooks. Okay, alright. So the action for the return of the ring fail. It's too bad. It's voidable. Then mean that here is possible to be valid, and it was valid as far as the case was concerned. Okay, what's the rationale of the judgment here? Okay, the court held that, well, identity was really not held to be crucial in Phillips and Brooke. Okay, all right, you are just mistaken with regards to credit worthiness. Okay, not really identity. So it's more a case of fraud, okay, rather than mistake here. Okay, all right, the mistake is only just about credit worthiness, not really mistake with regards to identity. Identity is like you can actually see him. Okay, you can verify whatsoever. Okay. Okay, the last part of our topic, effects and remedy. Okay, what happened to the contract which is affected by mistake, tainted with mistake here? Okay, as what we have discussed earlier on, okay, in our Contracts Act for Section 21, okay, provided it is a matter of fact essential to the agreement, so the contract or the agreement becomes void. There's no way for the contract to be valid. But if it is a case of unilateral mistake here, the agreement is not voidable, which means valid. But section 23, it doesn't say clearly, is it with regards to subject matter? Okay, but we submit it is, okay, because why 21 is about subject matter. Is it about contracting party? Okay, it doesn't say. So can we apply this rule for all? I mean, for subject matter, for contracting party? Maybe, right? Okay, for what's the remedy, okay, which is available to the victim, okay, all right, the one who is under a mistake here, all right. So restitution. So we restore the party back to their earlier position. So under section 66, and then in some situation, wherever relevant, okay, it's possible for the court to instruct for rectification, okay, to do some correction to the written document, okay, as provided under section 30 of specific relief act. Okay, that's all for the topic mistake. I hope you are able to understand, okay, all the important points. Okay, so we have 4 parts altogether. Okay, for the topic mistake. Okay, so please try to understand. Okay, if you have any problem, don't hesitate to ask me. Okay, you can forward your question to me, or we can have some discussion later. Okay. All right, okay, that's all. Thanks a lot. Okay, so we are going to continue with our next topic later. Okay, all right. Assalamualaikum warahmatullahi wabarakatuh.